Hello, hi, and welcome to this immigration webinar. My name is Caroline Boucher. I'm the director of the International Mobility Team at Montreal International, and I'm accompanied by Mr. Andres Pareja, a lawyer, immigration manager from KPMG law firm in Montreal.
Hey everyone.
The purpose of this webinar is to shed light on various information, decrees, and measures that have come out the past few weeks, and to give you an overview of the current situation, mainly concerning foreign workers and their family members, and above all, give you strategic tools to help you face the current compliance challenges due to the COVID-19. To protect the health of the Canadian from the COVID-19, the Prime Minister announced a travel restriction to Canada. These measures have evolved over the past 3 weeks. There was decrees after decrees, and then a variety of measures and directives that followed. So that you can understand, a decree is the law. It's what's written. It's what we should be basing our decisions on. But then the Canadian government also issues some measures or directive, and these are the instructions that the immigration agents receive. So these are usually what they will apply. So there could be a difference between the decrees and the measures or directive. And this is what we're going to try to clarify for you today. We've had many conversations within the last few weeks with Service Canada and immigration government. And today we have a clear vision of the situation, and we are happy to share it to share this vision with you today through this webinar. Be aware that there will be a small question period at the end of this presentation. We will not be able to take all your questions. We have over 100 person within this webinar today, but we did receive many questions prior to this webinar, and we've tried to cover as many as possible within this programmation today. We will not be able to answer very specific or personal cases, since we would need to analyze the full complete application before giving you an advice on this situation. But rest assured, as I said, we tried to cover as many questions as possible, and we will also look at a few questions afterwards if there is still anything that needs to be understood or covered. So let's begin. I'm going to start, and then Andres will continue. First thing that I would like to explain before we do start is that there's three definitions: one concerning the work permit, letter of instruction, and the letter of authorization. And these are words that you will hear often within this presentation. So I would like to make sure that you understand the difference between the three of them. So first of all, a work permit is a legal document. It's a document that is issued by an officer to a foreign worker that will actually allow him to work in Canada. The letter of introduction, which is also called sometimes the correspondence letter or the introduction or introductory letter, this is a letter. And this letter, you get it when you apply for work permit from outside Canada. For example, you apply online, and then when the immigration agent is ready to confirm that your work permit has been accepted, they will not provide the work permit, because a work permit is always issued at a point of entry. So what they will give you is a letter of introduction. And this letter, you need to bring it with you when you come to Montreal or to Canada, and ask for your work permit at a point of entry. The letter of authorization, this is something that is new since COVID-19, and mainly it's because there's a lot of restriction to traveling, and there's a few exemptions. So to confirm that you are one of these exemptions, you need to contact the immigration government, or which is IRCC, or you could talk to the Global Affairs Canada, or you could talk to the CBSA, and they will provide that document. What I mean by talk is obviously not over the phone. What I meant is that you need to contact them. There's an email address that we'll give you a little bit later on, but you could also contact them by contacting the embassy or the consulate, and you will get either a letter or an email that you have to print and bring with you to the border. So these are the 3 different definitions that I wanted to see with you today. Let's see who can enter Canada. Knowing that this presentation mainly concerned temporary foreign workers and their family members, we have not given here the list of all the people that can enter Canada. You can, obviously, as a Canadian or as a permanent resident, you can come back to Canada. But I could also talk to you about a foreign national that would come to Canada to make medical deliveries, for example. We wanted to target foreign nationals. So here we mention spouses of Canadians or permanent resident who is not also a Canadian, for example, or a person who has received authorization in written from the immigration or consular office. That could be a immediate family member of a foreign or a international student that is already in Canada, but that could also be someone that received a invitation from the Ministry of Health to contribute to the measures taken in response of that COVID-19. We now have a confirmation, which is a very good news, that international students and foreign workers can now come back to Canada. Here's in more details who can actually come back. If you are a foreign international student and you already have a valid study permit, you can come back to Canada. If you have the letter of instruction, remember that the letter of instruction is the letter that explains that your study permit has been approved. If you have this letter and it has been dated before March 18 to 20, you can also return to Canada. You are exempt from the travel restrictions. As a worker, if you have your work permit or a letter of instruction, you can also come back to Canada. You do not have to have a letter that is dated before March 18. Any instruction letter, even the ones that have been issued after March 18, is still good. You can come as a foreign worker. Miguel and I talked before this presentation and during the last few weeks, and we received a lot of questions. And one of them was concerning the question of essential employment. The first decree limited the entry of foreign workers to people who would come to Canada to occupy essential jobs. Sorry. But this is no longer the case. Any foreign worker who is granted a letter of instruction will be able to travel and to take up his position in Canada. Immigration Canada has not yet established a critical position or essential employment list or definition, although we do know that there are certain industries such as freight, food, and health, to only name a few. There is not a specific list that says, okay, this is a essential position or job. But what we do know is that if you are recognized as a essential position, you will be exempt of the 14 days of compulsory isolation for every other travelers entering Canada. Immediate family members. The definition as we know it in the immigration and refugee. Sorry, I'm just going to put back the slide. Okay, sorry. Okay. The definition as we know it in the Immigration and Refugee Protection Act has been expanded in the emergency order number 2. Among other things, they added, for example, the parents and the in-laws and spouses. So now we have spouses and common law partner, we have their children and the dependent children of their children's, but we also have now parents and in-laws and the spouses of common laws and any custodian or guardians. So the definition of immediate family has been expanded from what we used to use into the Immigration and Refugee Protection Act. Now we're going to look at a table chart concerning the family members. I'm sorry. Okay. Here's the chart. Remember that this chart only concerns family members seeking to join a temporary foreign worker or student, for example. Because if you are a foreign worker or a foreign student, you do not need to get that letter of acceptance, allowing you to travel back to Canada. So here, this chart concerns a spouse that would ask for a work permit, for example. Even though if she has already a work permit or a study permit, from the instruction that we receive, she should be able to enter to aboard a plane. But just to make sure, we do suggest that you apply for that letter of acceptance before she does so. So here's a few scenarios. If depending on your nationality, you either need a temporary resident visa or an electronic travel authorization. So you need to add either one of them to come to Canada. So, for example, if you come from France, you would need an ETA. If you want to get that ETA, you have to apply. We did include the link here. You have to apply, and then in the purpose of the visit, you have to explain that you are coming to be reunited with your family or your family member, which is a temporary worker, for example, that is already in Canada. Once you get that ETA number, again, then you have to apply for that letter of authorization that will be provided by Canadian Immigration, or, as I said before, Global Affairs or CBSA. Same thing, if you, like I said, if you already have that ETA number or that temporary resident visa number or the work permit or the study permit, we do suggest that you still then apply for the letter of authorization. At the bottom of the page, we gave you an example of the documents that you should send when you apply for that letter of authorization. First of all, to prove who you are, you need to send a copy of your ID page of passport, the one of the ID page of passport of your spouse already in Canada, the copy of his legal status in Canada, for example, a copy of the work permit or the study permit, and then the proof of your relationship. If you are married, if you have common law, proof that you've been living together for at least 12 months, if it's the birth certificate, if it's your dad, for example. And then you also include the proof that you've already received an ETA number or a work permit or the TRV visa. If you do want to apply for a work permit or a study permit, you have to apply within the same system that we used to do before COVID-19, which means you do apply online, and then you're going to have to complete more forms and present more documents. And eventually, the Canadian government will ask for a medical exam and most likely police certificates and biometrics data. This is where it's going to be more complicated because the system, the offices that do where you can apply for your biometrics are mostly closed. So just we can do an overview of who could apply for a work permit. As I said before, it used to be they were talking at the beginning of essentials occupations only, but this is no longer the case. So if you do want to apply for a work permit, or if your company needs to apply for LMIA, which is a labor market impact assessment, and apply for Quebec's acceptance or certificate acceptance from the Quebec government, this is also working right now. Service Canada and the MIFI, the Quebec government, are treating LMIA and certificate of acceptance from Quebec applications. The Service Canada even created an email so that you can send your LMIA request instead of doing it by fax. So afterwards, after getting that LMIA and CQ, the candidate can apply for his work permit. It's also true if you want to apply for a work permit that is exempt from the LMIA under the International Mobility Program. The employer can always complete his job offer into his immigration portal, employer portal, and then afterwards the candidate can apply for his work permit. Work permits, the process, it's a work permit application that is done online. You can no longer simply request an ETA and then take a plane and request your work permit as an intra-company transfer, for example, at a point of entry, because the exemption is given only to someone that already has a work permit or a letter of instruction. So if you don't have any either one of them, you need to apply for the work permit outside Canada before being able to come so that you can get that letter of instruction. If you do not have those in hand, the airline will refuse your access to the plane because you are not one of these exemptions from the travel restriction. The current obstacles that we're facing, because we do submit application for work permit, and but the thing is, as I said, the visa application centers, are mostly closed. If you look at France, Italy, Spain, UK, all these VAX offices are closed. If you're thinking about Switzerland or Belgium, they don't even have any. So to be able to go do your biometrics, which are your fingerprints and picture of the eye, you need to find a VAC that is open. And this is almost impossible or very rare to find. And if you do find one, you need to find a way to get there. So, and it's not always possible to get a plane and to travel within countries. And then even if you do, and if you're able to, you need to find a VAC that will give you an appointment. So from what we're looking at, it seems very complicated to get those biometrics done. Same thing for the medical exam. The designated doctors are still doing medical exam, but then you need to get an appointment, and it's not that easy to get one, and you don't get them as fast as you used to because they are also working very part-time. So what we're facing with these applications that we're sending is that people cannot provide those biometrics or the medical exam. So the government, Immigration Canada, gives them an additional 90 days to submit those applications or those biometrics data. So these are a few of the obstacles that we're looking at this moment. On the next page, we provided a list of documents that you can present to the airline. Let me just, switch page. Okay, sorry. When you arrive on your check-in, when you want to check in your flight, it's for the immediate family member that wants to come to Montreal to be reunited with a foreign worker or foreign student. They will have to provide the authorization that exempts them from the travel restriction in Canada for the purpose of family reunification. So they will need to bring this letter or a copy of the email that they've received from the embassy, the consulate, that allows them to travel to Canada. Of course, they need a valid passport, and they need to show their ETA number or the temporary resident visa that they've received in their passport before boarding the plane. They also have to show the airline isolation plan for the next 14 days after their arrival in Canada, that isolation plan is also required for any foreign workers or foreign students coming back to Canada. Like I said, the only ones that are exempt from that plan are the ones that will come to Canada for an essential position. This is when they can be exempt from that plan. If you are a temporary worker or a student, foreign student, you do not need to show the authorization to exempt you from traveling. You only need to show a copy of your work permit. And in the case of temporary worker, we do suggest that you also bring a letter from the employer in Canada that wants to hire you, so that they understand that you are still needed in Canada at this moment, that there's a job waiting for you, and that the employer wants you to come as soon as possible. For the student, you could either show your study permit or the letter of instruction, but remember that the letter needs to have been dated before March 2020, and a proof that registration or admission to a designated educational institution in Quebec. Even though there's going to be verification of your if you have any health symptom before boarding the plane, even though when you arrive in Canada, they will also verify that you do not have any symptoms of COVID-19, in particular fever, cough, or difficulty in breathing. And then that you also, again, have a plan for the next 14 days to make sure that you're going to stay home. You're going to be isolated for 14 days. And again, this restriction will only be exempted for people like, for example, a trucker who regularly crosses the border to maintain the flow of goods. That person will be exempt from that isolation plan. Otherwise, everyone coming to Canada needs to stay home for at least 14 days before being able to leave the house. This is all for me for that part of the presentation. I'm going to let my colleague Andres give you the information on temporary residents that are in Canada, and information on compliances concerning your LMIAs and the work permits. So please, Andres.
Thank you, Caroline. Indeed, we are facing challenges. Let's talk about the foreign workers who are currently in Canada and whose status will expire soon. They probably, if they're visa national exempts, had travel plans and were planning to or considering to apply for a work permit at the port of entry. Fortunately, this straightforward strategy must be reviewed, and the reason is quite simple. We can no longer apply for a work permit at the port of entry unless it is an essential work. So right now, in Canada, we don't have an automatic extension. You must file an online extension to make sure that you are on implied status, and if the work permit will expire soon. And also, given the delay in the processing applications are going up, you want to make sure that you're filling an application as early as possible. Now, what happens if we receive the biometrics letters, instruction letter? The letter provides 30 days to submit your fingerprints. And the applicant who reach out to Service Canada's office is informed that this office across the country are now closed. Of course, no one is expected to do the impossible. Could the file be subject to refusal by IRCC? The answer is no. The government has decided to extend the deadline to 90 days instead of 30 days for the biometric collection. We must remain optimistic. I believe that the government is responding well and understands the situation being presented. Now that's why new information is coming every day, and now how people are going to be accommodated. So even if it's 90 days now, perhaps in the future, it could be extended if necessary, and that's positive, and more changes could be coming. I will address later in detail the question or the case of the employee who has been laid off, and how, in a spirit of compliance, the employer can support the employee with the renewal of his work permit. I understand from my colleagues in labor law that a layoff does not end the employee-employer relationship, but is expected that the employee will be called back as soon as the economic situation of the company allows it. So, but if we push our reasoning further, the employer knows that the worker will not receive a salary, but rather will receive employment insurance benefits, if, of course, if they are eligible. As an employer, you must be extra careful on what you're going to indicate in your offer of employment via the employer portal. This is something to consider given the compliance issues. As for the strategy for a work permit renewal for an employee that has been laid off, this is a great area. As an employer, you want to ensure that your worker maintains his legal temporary status to avoid a situation where he will run out of his status. It is very important to apply well before your current status expires, so you can continue having that employee-employer relationship. You need to be transparent in your offer of employment and explain the circumstances to IRCC. For example, when it comes in terms of salary, be transparent in the terms that the person will be paid once the business situation gets better, once the operations and activities will start again. Again, this is a gray area. This is not a situation where you will find the solution online, where you will do first do A and then do B and the result will C. This is not the case. And even in a case where the work permit is not necessarily expiring in the next couple of months, but until the next year, we can forget that in an event of a layoff, the employer-employer link remains, and it is essentially a change of the employment conditions, meaning that there is a breach of compliance because you're not paying your employee. It needs to be disclosed, and there is ways of accomplishing that. For those who hold a closed work permit and who continue to have an employment relation with their current employer, they will be able to benefit from employee status. The same will apply to the open work permit holders. But if we flip the other side of the equation, those having a closed work permit and who wish to change of employer will have to wait for the issuance of the new work permit to proceed with such change, and will not be able to present themselves to LACOL, Sunset, or other port of entry. The Canadian Border Service Agency will not process any immigration application at the port of entry except for workers performing in an essential industry. So at the beginning of the presentation, Caroline talked about the rule of essential work limited to certain industry, for instance, the food, transportation of goods and equipment, medicine. Our team has contacted several port of entries across the country, and is the rule that the CBSA is implementing. As such, we do not recommend the flag pulling. However, this makes me think, if you believe that you have an essential worker case, and the only option is to obtain a work permit as soon as possible by presenting yourself at the port of entry, well, in this case, come see us and we will look together into the situation and come up with a solution, because there isn't really a definition of what is essential. Is there a certain or a specific approach? The answer is no. But if you have a case deemed crucial, not only for your business, but in the public interest, then we could look at the several steps to arrive at a good solution and get a work permit as soon as possible. Having that in mind, it gets me back to our original recommendation, that is to submit an online work permit application as early as possible. And just to give you an example, let's take, for example, the case of a French national and who is a work permit holder issued under the intra-company transfer, and who is currently outside of Canada, but is expected to fly in the next couple of weeks. And his intention is to change his employment or his employer, because let's say that he holds a Quebec selection certificate and is really urgent for this person to change his employment or his employer. What could he do in these circumstances? There is no magic recipe. Are there certain channels that we can use? Certainly. It's all a question about strategy, and there are many ways to navigate and some way look at the case together. And I mean, Canada wants to benefit from essential services, essential workers, and especially those who will be helping this pandemic. So each case is different, and we can certainly review the different strategies to confirm that a case can be successful or not at the port of entry. So now let's move to the compliance aspect. What you have submitted in the employment online offer via the employer portal or through an LMIA application, a labor market assessment impact application, does not only represents the undertaking to your foreign national, but mostly importantly with the Canadian government. And you have some obligations regarding the conditions of employment, and there are consequences in the event of non-compliance. It is certain that we are going through an exceptional situation which requires exceptional measures. My opinion is that the government knows that there are tough decisions to be made by many small, big, or multinational businesses right now. But as long as the government doesn't adopt clear guidelines with respect to layoff situation and the impact from an immigration standpoint, we're confronted with a potential compliance issue. So our advice is to be organized and prepare your plan for your business. It might seem rudimentary, but preparing a table with the people that are impacted, what type of work permits they have, the employment conditions actually that are set in the employer portal or in the LMIA, what are the changes and which one of these changes are temporary or permanent. And then we can go case by case and see what needs to be done in order to ensure that you are protecting the company's reputation with respect to the authorities and taking the appropriate measures to ensure that you are compliant as possible, but realizing that you may have to follow up in a justification of a non-compliance as well. So one of the things that we will consider is a voluntary disclosure. But at this point, we understand we will start by assessing each situation and seeing what are the compliance breaches involved and how can we protect the integrity of the company and what other further measures may be available to us. So it is not because we are in a pandemic context that your obligations as an employer does no longer exist. The AIRPA and the immigration regulations are still there. However, we remain sensitive and we understand that some companies cannot just wait to receive clear instructions from the federal government, and they have to face important internal measures and need to take difficult situations regarding their staff. So one thing to keep in mind is to always have the following reflexes. Is it still the same position that your employee holds? If there are any changes in his duties, Or is there a new national occupation code resulting from this change of the duties? So you have to think all of this, and let's be honest that sometimes you forget about it, especially in situations where you have to act quickly and in the best interest of your company. I'm referring to the typical case where the employer has laid off an employee and who is considering more layoff and will tell the employee to do or complete some type of work of his colleague. But if we need to remember something from this discussion is that we must be as a company that is organized, that is documenting the current situation, keeping every track, and is ready to do and just be ready to do a voluntary disclosure and do whatever it takes to maintain the company alive and at the end of the day save jobs. So we all know that audits are becoming more and more regular, and this situation will continue to increase. But because we need to stay positive, especially as employers, to know that the federal government will respond to companies that are facing this situation and that they know that the companies are proceeding with layoff. Just remember, it's not just temporary foreign workers who are affected, but the whole society. No one is exempted. And I mean, you and I were all working from home at this point. So this is definitely, this will definitely change the way we face and do compliance. I wanted to give you an example. Let's talk about an employee, Bob. Bob is a key employee, and there is currently not enough work for him. He holds a work permit under NAFTA professional, and Yannick, his employer, and my client reach out to find out what to do with Bob because he might reduce his work hours because obviously the business doesn't have enough work for him, and they don't want to pay Bob because there's no work. He needs to know what to do. So with the current obligations, if we change the terms of employment, it is clear that this is a violation of your obligations. And normally what the employer should do is that they will provide a voluntary disclosure and submit a new application with the reduced hours as it involves a change in working conditions. So what will be the consequences if the employer proceeds with a reduction of Bob's working hours? Well, if he decides to do nothing, he will be subject to penalties. There are penalties for non-compliance if these justifications are not accepted. But once again, we expect further guidance from the federal government regarding clear measures, since this affects a lot of people and employees and employers. While waiting for more guidance, be mindful of what the law and the immigration regulations states, including mainly Section 203 of the regulations, which announce two defenses in terms of compliance. The first one happens when the company must take measures in a difficult economic context. And secondly, we refer to force majeure, act of God, concepts that are used in private and contractual relationships rather than in immigration context. As an employer, you have probably already thought about certain measures that would allow the company to cope with the current loss of income, loss of contracts, and therefore being forced in the current circumstances to reduce the number of hours of your employees. If this is the case, you must apply the measures uniformly with the same work unit for similar positions, without the temporary status of an employee being a criterion when it comes to a layoff or a reduction of hours. Their immigration status is not relevant. Employees, whether they are Canadian citizens, permanent residents, or temporary foreign workers who hold a similar position, should also be subject to similar measure, so it's not discrimination. Now, will the concept of force majeure apply to COVID-19? I think it does. Um, the Quebec government has issued emergency decrees that restrict the economy activities of business in Quebec. We're basically being told, stop your activities, stop operating, stay at home. So they probably will accept the force majeure. Um, but unlike the common law provinces in Quebec, the Code civil du Québec defines force majeure, and the courts in Quebec have already considered in a private and contractual context the H1N1 virus as a case of force majeure. So we don't have that precedent in an immigration context, but you're not alone in this situation. The government knows it, and nobody has a crystal ball to predict the future. One thing is certain: is a question of time. Everything in life is temporary, and it's going to be fine. One advice that Caroline and I would like to share with you is that given that it's difficult to bring new employees in, as a global mobility and human resource people, you might want to look at your current work permit holders and see the conditions in their work permits and see if you can redeploy resources to different projects. It's all about being strategic. And also to have in mind that this is an opportunity to support, promote, or encourage the process of permanent residency for your foreign workers. This morning, the Quebec government indicated that the processing times for issuing a CSQ, whether it's under the fast track program or the regular program, will increase. So we expect that the processing times will increase for both of the programs. But at the end of the day, the Quebec government continues to operate and continues to issue the Quebec selection certificates in the different economic programs that we have. And this will basically, having a permanent residency will prevent your workers to constantly needing to renew their work permits. There are different vehicles that exist, and I'm pretty sure that you might already be looking this with your employment and labor council, such as the work sharing from Service Canada. This is a program that will give to some employees employment insurance benefits, but there's different criteria to respect from both the employee and the employer. So we invite you to contact Service Canada if you think that as an employer you will be eligible for one of those programs. There's also different programs from the federal government and the provincial one in terms of financial support. And I believe, Caroline, and correct me if I'm wrong, but Montréal International will be making a webinar next week and the next couple of weeks about the employment insurance and the different aspects in labor law.
Yes, there's going to be a webinar next April 15 concerning the offer from the Canadian government to provide a 75% wage subsidy to any businesses that are eligible. I see, because this came out today, from what I understand, there's a French webinar at 2:00. I don't know if there's going to be an English one for now, but the information that I have is that there's going to be one next Wednesday, April 15 at 2. Thank you very much, Andres, for this presentation and for all the clarification. We're going to look at a few questions if we can try to help you. The International Mobility Work Unit, Immigration and provides this authorization letter. No, this unit does not provide authorization letter. This unit provides if you want to send a request to see their opinions on a certain type of work of LMI exemption, for example, this is the unit where you can send your the opinion request, but this has nothing to do with the authorization letter. What if the children wanting to join their father who is in Canada are exempt from the obligation to obtain a study permit, CAQ, and visa? How do we go about having them come here? That's the exact situation for any immediate family members of a foreign workers. I guess that's the thing. You don't say what that does in Canada. So it all depends if he's a Canadian or if he's a foreign worker or a foreign student. But there is a few situations, and if you look at the chart that we've provided before, and this presentation, this webinar will be on Montreal International website, so you can look it at afterwards. But depending on what the father does in Montreal or what his legal status is in Canada, this changes the answer that we can provide. Miguel, you want to look at this question?
For the applicants of the Global Talent Stream program, they need to come to Canada to activate their work permits. Are they exempt from the travel restrictions? So it will depend where the person is. I believe you are referring to someone who is currently abroad. So if the person is currently in abroad, they need to follow to submit an application through the visa office and follow the different steps that Caroline mentioned in the presentation, where you need to wait for the biometrics collection and wait until further guidance from IRCC. The situation is evolving, but we do foresee many obstacles in terms of processing times when applying for a work permit abroad.
Yes, if I could add to that, mainly you have to keep in mind that the people that are exempt, the workers that are exempt from the travel restrictions are the ones that already have a work permit or have a letter of instruction. So as Andres just said, if you apply online for the work permit and are able to provide your biometrics and everything, then you will get that letter of instruction, and then you will be able to travel back to Canada. Last question. Will they approve an application without biometrics and require the applicant to do them at a later date with centers open? They do not approve application without biometrics. What they will do is allow you an extra 90 days so that you can eventually provide those biometrics when the centers open again, and then they will finalize the treatment of your file.
Just a quick note on that. The biometrics are due to security reasons. So this is something that the government will not waive the applicant, and we need to wait further guidance. As I say, now we have 90 days. Maybe the situation will change as well, and the government will extend the delay for that type of process.
This is going to be it for this webinar. We thank you for being here and for all your questions. We will have all your questions, so we'll keep them in mind and we'll look at them and probably provide a Q&A section underneath the webinar on our website to answer mostly of all your questions that we've seen today. So thank you very much. Thank you, Andres. Thank you for being here, and have a good day.